Kink the tripod out somehow. Your legs are not, you're off kilter.
Yeah.
Spread it out properly. There you go.
We get it on video, Collie. All on video.
So I'm just gonna
Yeah, you're
do
going to get me sideways. Ladies and gentlemen, thank you for joining me here today. I'm very proud to stand with all of you as we try to take our state back. I wanted one's attention that I filed a criminal complaint against Christopher T. Sununu for his emergency orders. Why are they a crime? They are a crime because he ignored the existing public health laws. He had the statutory authority to declare an emergency. We're not arguing that there was an infectious disease. We're not arguing that there was a declared emergency. The first thing he had a duty to, under his oath, was to enforce the existing health laws. They were already on the books. They've been on the books for 238 years. So what did he do? He lied to the court. He lied to the people. And so such a crime is a Class B misdemeanor. It's called unlawful simulation of the legal process. And here is the definition of the crime. A person is guilty of a misdemeanor who, with the purpose to procure compliance of another, with a request made by such a person, knowingly sends, mails, or delivers to such a person a notice or other writing which has no judicial or other sanction, but which in its format or appearance simulates a summons. In other words, his letterhead, all of his correspondence where he says, I'm the governor and you shall comply, that these are mandatory orders. Okay, he gave the illusion that what he was doing was ethical and lawful, and they weren't. So to continue, it simulates a summons, a complaint, a court order or process, including but not limited to a lien, indictment, warrant, injunction, writ, notice, pleading, subpoena, or order, or insignia, seal, or printed form of federal, state, or local government, or an instrumentality thereof, was otherwise, and here's the catch, was otherwise calculated to induce a belief that it does have judicial or other sanction. Is that what it looked like, folks? Right? Didn't it look like it was legitimate? Well, he's got some major problems with this because it's true. It's true. And so what he was supposed to do is, as soon as he declared an emergency, he had a duty to enforce 21P53, which, by the way, he now says is in effect. 21P53 is the emergency management powers statutes that govern his conduct. He was only capable of using the public health department, which he was doing, and still is doing, but they had some restrictions. It's called your rights. 21P53 says that in a declared state of emergency, the public health law 141C14A, that is your rights to due process. It says that all they were capable of doing was, if they suspected, if any member of public health department thought that you were a risk to public safety or public health, they could issue you a quarantine order. When they gave you the order, on the back was your right to contest. Upon service of an order, you could say, I don't consent to this quarantine, and you can file it, sign it, and hand it back to the officer who served it to you. They have to get you to a courtroom in 48 hours. 120 hours is the max, and if you're not in the courtroom by that time, throw the order out the window because it's no longer legally binding because they violated your right to due process. In that order, at the hearing, the state would have been required to prove beyond a reasonable doubt that you were a risk to public health and public safety. This was a problem for the agenda. Sununu's agenda from the beginning has always been about big pharma, supporting Moderna, and vaccinating this population for their profit. To hell with the damage he's done to our culture, to our state, to the lives and businesses that he's destroyed. And he needs to be held accountable. Now, I can only prosecute him under common law. The reason you can do this, New Hampshire, because it's so old, was settled in 1622. It was in effect for 150 years by the time the New Hampshire Constitution was written. And when it did so, it wrote Article 90 that said all the laws and customs that were in effect when this document was written will carry forward into our new form of government until repealed by the legislature. And so, because of that provision, under common law, it was common to private citizens to prosecute low-level criminal offenses. Actually, back in the day, In the colonial period, you could prosecute all kinds of cases, not limited to, but the Constitution does provide, the state Constitution does provide your protection if you are accused of a crime to a trial by jury. Because of that, we are now restricted to only Class B misdemeanors. The statute I just read to you is a Class B misdemeanor. It's 115 of them. If anyone's ever heard the quote, fruit of the poisonous tree, fruit of the poisonous tree, the first order was fraud. So all the subsequent, he wrote 26 orders, my last count, and 26 executive and 88 emergency orders, all under the simulation that he had the authority to do so, and he didn't. So, this was filed on Tuesday, Candia, New Hampshire, the local district court where you file a low-level criminal offense. I called this morning. They're still trying to figure out what to do with it, because the clerk, her name is Maureen Murphy, very nice lady. The staff there was completely professional, and I appreciate their excellent conduct because they were really, really professional. She said, as you know, Mr. Richard, you're invoking something most of us have never seen or understand. She says, I saw that you did your homework, that you cited the state Supreme Court in 2002. And that case, so for the benefit of the audience, is a man in Berlin, New Hampshire was assaulted by his neighbor. The local prosecutor refused to bring a criminal complaint for the simple assault. He did the same thing that I'm doing, but he charged a Class A misdemeanor. Class A misdemeanor would have subjected the defendant to jail time, and therefore they couldn't proceed, but they reaffirmed the right. So this is a right that all of you can exercise. Every one of you, and I'll be glad to send it to everyone. Any of you who have enough experience to defend yourself in a courtroom can bring this action. It's a simple complaint. He had a duty. I lay it all out for you. And so now it's in their hands. So the question is, and this is why I called you today to assemble. Number one, so that this doesn't go away. By myself, I'm one man. With all of you, the numbers change. You see how fast people change their attitude when it involves a larger group of people. And so what they're going to do is try to find a way to kill it, because the criminal complaint implicates Chief Justice Gordon MacDonald, who was the Attorney General at the time. It also implicates John Formella, the new Attorney General, who was part of the architect of the fraud. And then it also implicates Justice Kissinger, because he allowed fraud to be committed in his court. And lastly, of course, is Daniel Will, the Solicitor General, who is the president of the New Hampshire Board. He's the chairman of the Board of Governors of the New Hampshire Bar Association. He's the big cheese, smart lawyer. He was the real brains behind the fraud. So they're all implicated in this, even though it's a low-level offense. So thank you for showing up today. And the only other update I have for you is the Writ of Mandamus. The preliminary hearing was scheduled on Wednesday. It was heard. The defense provided me with a motion to dismiss late Tuesday night. The court has given me, as it should, the opportunity to respond in writing. That hearing is on at the end of the month, on the 30th of the month, on Friday, same time, 2:30. Keep posted to New Hampshire COS. We'll keep you updated. It looks very, very good. They don't have an excuse. The state legislature, and this should concern everyone here, our form of government this place was called the General Court for a reason. It's because it heard the grievances of the people. And based on the historical usage and custom in the state, I discovered that there were more than 18,000 petitions filed from the colonial period into the 1860s. 18,000. So this body is designed to hear your grievances. And it used to be the first duty of the speaker every day was to say to his representatives before him, does anyone have a petition to bring forward today? And if they did, to represent the will of the people, they would bring it forward, and then it would be heard, considered, and sent to a committee if it would be committed into a bill. They've taken that from you, and they've done it by one simple mechanism. They changed the rules of procedure in the House to kill them. The duty of the Speaker has now been removed from Rule 4 of the current rules. It's been moved to Rule 18. Rule 18 is a bunch of fancy mumbo jumbo that says in the end, it ends up in the clerk's office on file. It removed the compulsory duty of the speaker to bring your business forward. And he's taken that from you. So now they've got a team of lawyers. And who are they representing? They're not representing you. They're not representing the people. They're professional, don't get me wrong. The point is, the status quo doesn't want to give the power back to the people. They want this place to run for the benefit of the two-party system. So when you vote for choice A or choice B, you're not voting for your rights or yourself. You're voting for whatever the party platform says, and we need to wake up and stop running our elections this way.
Amen.
God bless all of you. Thank you for coming. Title of the statute and the body of the text. The governor has instructed someone to insert the following: NH-LEGIS, E period, O period, in order to deceive the reader of the state website into believing that these emergency orders had the sanction of law, and they don't. Because the legislature didn't issue executive orders, he did.
Yep.
So why has he written NH-LEGIS, E period, O period, and then added all of the orders and their numbers?
Right.
That's intent to deceive. In criminal law, that's called mens rea, criminal intent.
Yep.
Is guilty.